Good morning, everyone. This is Michelle Bach. I am the president of the Safety Council, and it is a pleasure to be with everyone today. But we look forward to having our meeting today, and Steve Roth is here. So I will turn it over to him for a few remarks, and then we will get to our speaker.
Thank you, Michelle. Good morning, everyone. Glad to be with you, albeit virtually this December. It's hard to believe we're closing in on the end of the year that shall not be named. For the latest information on COVID-19 in Ohio, please visit coronavirus.ohio.gov. At the urging of Governor DeWine, the BWC board voted unanimously to approve issuing $5 billion in dividends to Ohio employers in mid-December to ease the financial pressures caused by the coronavirus pandemic. This is nearly 4 times the dividend BWC issued in October, bringing total dividends this year to nearly $8 billion. In Montgomery County alone, this dividend will be approximately $194 million. Employers should expect to see their checks in the mail in mid-December. The state of Ohio has launched a financial assistance program to reimburse facilities serving older Ohioans that invest in air quality and airflow improvements during the COVID-19 pandemic. The federally funded program reimburses up to $15,000 to Ohio nursing homes, assisted living centers, and adult day centers that invested in air quality improvements on or after March 1st, 2020, and prior to December 30th of this year. December 30th of this year. Please visit bwc.ohio.gov for more information and to submit an application by the December 30th deadline. Our annual Ohio Safety Congress and Expo will be an online-only event in 2021. Mark your calendars for March 10th and 11th. The event will feature dozens of learning sessions and a digital expo. As always, the event is free for Ohio employers. We will open registration at ohiosafetycongress.com in January 2021. Also save these dates, April 8th, 9th, and 10th, 2021, for our first ever online medical and health symposium, offering free learning opportunities and continuing education credits. We invite healthcare professionals, practitioners and their staff, office administrators, and legal professionals to join our online interactive symposium. Online registration will open in January. There are 2 new BWC safety resources on our website under the Safety and Video Library. We've created a new series of safety talks and written safety program templates. Each safety talk is a short training program with group activities and a list of educational resources to learn more about the topic. The sample written programs are templates to assist you with developing a customized program for your workplace. BWC's Division of Safety and Hygiene continues our series of free webinars offering a variety of workplace safety topics, or covering a variety of workplace safety topics. Each week, safety experts conduct these 1-hour webinars on Tuesdays at 11 a.m. In December, our remaining lineup is going to be on the 15th. We're going to have accident analysis. Why should I do it? On December 22nd, winning management commitment. And we're going to round out the year on December 29th with lockout, tagout, controlling hazardous energy in your company program. To register, visit bwc.ohio.gov and search for safety webinars. We continue to deliver live online training classes as well. Our December lineup consists of the OSHA record keeping half-day workshop. That's going to be December 16th from 9:30 to 1 p.m. These courses delivering using WebEx will be similar to the courses you may have attended in our training centers. They will offer BWC credits for those who need to earn credits for the various BWC discount programs, and registration is through the BWC Learning Center. For those public employers involved in the industry-specific safety program, you have until the end of this month to complete your 3 loss prevention activity credits to earn your 3% premium rebate. I also like to wish everyone a safe and joyful holiday season as we finish this year. Our speaker this morning is Joshua Lounsbury with Coolidge Law. Josh concentrates his practice in the area of workers' compensation defense and is a certified specialist in workers' compensation law by the Ohio State Bar Association. Josh has represented employers in more than 1,000 hearings before the Industrial Commission of Ohio. In addition to representing employers at hearings and trials, Josh assists employers with day-to-day claims management, injury investigation, actuarial analysis, and cost-saving strategies. Please join me in welcoming Joshua Lansbury.
As mentioned, my name is Josh Lounsbury. I'm an attorney at Coolidge Wall. I've been there now for 16 years, and I am a certified workers' compensation specialist by the Ohio State Bar Association. A lot of what I do is handle hearings. I've handled over 1,000 hearings. It's probably safe to say I've handled thousands of hearings at this time. I've handled trials. I've handled cases in the Court of Appeals. I even have a successful appeal in the Supreme Court of Ohio. But a lot of what I do is advising employers on what to do when a claim is filed, whether they have a legal defense, whether someone's off of work, and what to do when someone's off of work. And today what I wanted to cover was one of those topics, the topic that comes up a lot from my clients, and that's what to do when you have an employee who has been injured at work and now they cannot return to their former position of employment. This comes up in many cases, at least initially. You're hoping that the person is off for a short period of time, but sometimes it's hard to tell from the very beginning. And so employers have to make sort of split-second decisions at the beginning of a claim on what to do. So there really are sort of three paths for what to do when someone is off of work. You can go the path of salary continuation. That's where you pay someone wages in lieu of receiving temporary total disability compensation. You can have them receive benefits through the Bureau of Workers' Compensation. That's called temporary total disability compensation. Or you can try to get them to return to work, albeit in a light duty capacity, not in their former position of employment. So I just want to go through those three alternatives and what the impacts of those alternatives are and how they affect how you handle a claim. So the first, as I mentioned, is salary continuation. This is where you pay wages, the regular wages, in lieu of the person receiving temporary total disability compensation. It's voluntary. You cannot make an employee take wage continuation. And I did have one client who had it in their union contract that they were required, but there is no state law that requires an employee to take wage continuation. Where I see that as an issue come up is, so if you receive temporary total disability compensation, it's based for the first 12 weeks on a short time period before you're injured. If you receive disability benefits beyond those 12 weeks, they use your past 52 weeks of compensation to determine your rate that you're going to receive compensation. Sometimes if an employee is new, that rate can be lower than what their regular salary is. But that doesn't mean you get to pay them at that rate. You have to pay them at what their regular compensation would have been at their former position of employment. This comes directly out of the employer's pocket. They have to pay for this. You know, you have insurance, workers' compensation insurance, for a reason. You'd question, why would anyone pay someone's salary when, you know, they're paying insurance premiums, and the BWC would pay temporary total disability compensation? Well, the reason for that, and the reason that many third-party administrators recommend that employers pay salary continuation, is because that will not affect the claims costs. So in determining your premiums, the Bureau looks at the amount of payroll you have, the type of employees you have, and then it looks at your claim experience. How much costs have gone into the claim, how many claims have you had, and how much costs are in those claims. So when temporary total disability compensation is paid in a claim, that builds up the costs in the claim, which will have a bigger impact on your premiums. The bigger impact, though, comes from the fact that as soon as temporary total disability compensation is paid in a claim, the Bureau will use its formula to set a reserve for your indemnity benefits. It's a calculation of what they believe the future benefits will be. So even though those benefits have not yet been paid, they'll be put into that calculation as to what your future premiums will be. So, you know, as soon as the temporary total disability check is paid, $200, suddenly you've got an $11,000, $12,000 reserve that could be affecting your future premium. So third-party administrators say, pay some salary continuation if you think this person is going to return to work quickly. because that way it won't affect your premiums as much as if you were to have this person on temporary total disability compensation. And, you know, lots of times employers are just on the cusp of what group rating they have or whether they're going to fall out of group. So it's very important for them to pay attention to whether salary continuation can help them keep in the group. There are some downsides to salary continuation. The biggest downside is there is no way to terminate salary continuation other than saying we're no longer going to pay you anymore, at which point the person is likely to switch directly back over to temporary total disability compensation. When that happens, all those things that you were trying to avoid, the increase in premiums based upon that payment of temporary total or the increase in your reserve figure, that's all out the window as soon as that first temporary total disability compensation check gets issued. So what I see is employers who get on this salary continuation, they think that someone is going to be off work for just 2 or 3 weeks, and you're on salary continuation for 3 or 4 months. At some point, you just have to say enough is enough. This is not worth it. Once again, you have workers' compensation insurance for a reason, and that's so you don't have to pay these costs out of pocket. Now, the Bureau, the Industrial Commission, which hears hearings on termination of temporary total, they will not hear a termination of salary continuation. The person has to be receiving temporary total disability compensation or requesting temporary total disability compensation for there to be jurisdiction to hear that issue, which is once again why you have no way of terminating salary continuation other than stop paying and them switching over to temporary total disability. As I mentioned, when the Bureau pays disability benefits, it's called temporary total disability compensation. That's defined by the Ohio Revised Code, section 412356. You can receive temporary total disability compensation when you are unable to return to your former position of employment. This doesn't mean you're incapable of working in any capacity. It just means you can't go back to the job you were working previously. So if you were a steel worker, even if you could do secretarial work or anything lighter than steel work, you would receive temporary total disability compensation until you're able to return to that job as a steel worker. It's supposed to be compensation for a short period of time while the person recuperates. I can tell you that it's sometimes years of temporary total disability compensation. I have an injured worker now who fell over in November of 2017, who is still receiving temporary total disability compensation. She had it terminated, requested additional conditions that were allowed, temporary total started again. Temporary total was about to be terminated based upon a finding of maximum medical improvement. She went forward with surgery. She was back on temporary total again. When she got done with the surgery and was supposed to be returning to work, she had a setback, developed another condition, which got additionally allowed in her claim. And then COVID hit, and she could not have surgery to recuperate from that condition. And finally, the Industrial Commission's, the Bureau set her up for an examination, at which point she went into vocational rehabilitation. So she's still on disability benefits, although it's not temporary total at this time. But these benefits are not sometimes as temporary as you would like them to be. The disability has to result from an allowed condition in the claim. So just as another example, I have an employee who fell over. His claim is allowed for a contusion of his trunk and for a lumbar sprain. He is scheduled for an examination on his extent of disability. He fell in February. He's still off, and his doctor is saying that it's related to those conditions. I have no doubt that it is not, but he's seeking additional conditions of herniated discs in his claim. Because those conditions are not currently allowed in the claim, he could not get temporary total disability for those conditions. It has to be for one of the allowed conditions, either the trunk contusion or the trunk sprain. The Industrial Commission and the Bureau of Workers' Compensation are very focused on what are the allowed versus non-allowed or disallowed conditions. The great thing about temporary total disability compensation is that it's no out-of-pocket expense to the employer. This is paid entirely by the Bureau of Workers' Compensation. But once again, the downside is that it's going to affect your workers' compensation premiums. The longer that someone's on temporary total disability compensation, the higher the claims costs are, and also the higher that reserve figure is going to be in the claim, which once again will affect how much you're going to pay in terms of your workers' compensation premiums in the future. So once someone is on temporary total, I mentioned I have an injured employee who's been out for 3 years now. I have another one who's been out for 9 months. How do you get them off of those benefits? Well, the easiest way is to have them return to work, whether it's in the full duty capacity, which is obviously the main goal, or in a light duty capacity. The moment they step foot back into work in any capacity, that ends their temporary total disability compensation. That's the easy one. Unfortunately, it's the easiest one in terms of terminating temporary total. It's the hardest one sometimes to get them to do. The other way that they can have temporary total disability compensation terminated is when their physician of record says that they're able to return to work. And I just had a hearing yesterday where the injured worker's physician of record said they could return to work. And the next day they sought a new physician of record who would take them off of work. And there are certain doctors who, in my experience, will never say that an employee is capable of returning to work. You can send them requests for light duty restrictions, and they will continue for years and years and years to say, nope, they're never going to be able to return to work. It's not until you take some form of action that you're able to get those people off of temporary total disability compensation, because their physician is not required to assist you. And oftentimes they're just in the mode of signing the Medco 14s, which are the forms that certify temporary total disability benefits. They just sign those every time the person comes in without ever really thinking about, how long has this person been off, and are they really, have a chance of improving at this point. A third way of terminating temporary total disability compensation is to make light duty work available to an employee. I've already covered what happens when light duty is made available and they return to work. What I'm talking about here is when you've offered light duty employment and they refuse to return to work. Under those circumstances, that will still result in a termination of temporary total disability compensation. However, there are some hoops that you'll have to jump through. A light duty job offer is defined in the Ohio Administrative Code. A job offer has to be made in good faith. I mean, if the person has kids and has always worked the day shift while the kids are in school, you can't make them, light duty can't be in the night shift. It has to be suitable employment, something that they can do within their restrictions, and it has to be within reasonable proximity of where they live. So if they live in Dayton, they've been working in Dayton, you can't shift them off and send them to the Columbus office for their light duty job. It has to be within reasonable proximity. It also has to be a written job offer. So I've got all of the language written up there. It can be verbal, but if you are going to, if they're going to refuse that job offer and you want this matter to go to hearing, it has to be written. And I'm just going to read from the statute because it is critically important. The written job offer has to identify the position offered and must include a description of the duties required of that position and clearly specify the physical demands of the job. If you file a motion with the Industrial Commission to terminate benefits, a copy of that offer has to accompany your initial filing for that. And I mean, I've been doing this for 16 years. I think I've seen employers do this on their own successfully a couple of times, but they've often fallen into the same pitfalls. The number one pitfall in offering a written light duty job offer that people think is sufficient is they'll send a letter to the claimant saying, we have a light duty job offer within your position, within your restrictions. Your restrictions are attached. Please show up on Monday. We've got a job for you. That does not meet the requirements of the administrative code. That doesn't identify the position that they're supposed to be filling, and it does nothing to explain what job duties they're going to do once they return to work. When I'm in a hearing on this issue, I need the hearing officer to see the light duty job offer, and they need to see the physical restrictions the claimant has. And they need to be able to see, okay, this is what the job offer says that they're going to, be sweeping floors, filing papers, and able to sit and stand at the desk as needed. Their restrictions are, they're only allowed to lift 5 pounds. They can sit and stand with breaks as needed. you need those two things to compare one to the other. So the hearing officer, who's not a party to this claim, who wasn't there for the written light duty job offer, to independently see that that light duty job offer meets those restrictions. If you just say in your job offer, this job offer meets these restrictions attached, the hearing officer has no idea what you expected the employee to do when they arrived at work. And categorically, those requests to terminate benefits are denied. This is one of those cases where I strongly recommend that employers get a second opinion before they issue a light duty job offer in writing, just to ensure that the offer that they're making is meeting those statutory and administrative code requirements in order to terminate temporary total disability compensation. Now, if you screw up and they still return to work, you're golden, because once again, an actual return to work will also terminate benefits. But we're just trying to be as conservative as possible and plan ahead. So if in the event that they say no, you still have a way of terminating benefits if you're able to provide light duty within their restrictions. So as mentioned, it must be in writing. If you do anything verbally, as mentioned in the administrative code, you have to make an offer in writing within 48 hours of filing your motion to terminate benefits after a refusal. So it doesn't even make sense to do one verbally because you know you're going to eventually have to make that step. Unless you know 100% the person is going to accept and return to work, just put it in writing just to make sure you've covered your bases and you have that potential defense in case they refuse to return to work. The number one tool I have in my bag as an employer's attorney is to get a finding of MMI. And we use lots of these little acronyms. MMI means maximum medical improvement. And you can see the graphic here is of a plateau. At least I hope that's a plateau. I think it looks more like a cliff with a plateau on top of it. So maximum medical improvement does not mean the person is 100%. It just means that the person has gotten as good as they can get. They've reached a treatment plateau from which no fundamental or functional physiological change can be expected. And here's the actual administrative code section that defines maximum medical improvement. Once again, it's a treatment plateau at which no fundamental, functional, or physiological change can be expected within reasonable medical probability. In spite of continuing medical and rehabilitative procedures, an injured worker may need supportive treatment to maintain this level of function. And one of the games that I see played is we get an MMI or extent of disability, an EOD examination scheduled for an injured worker. The moment that is on the schedule, the injured worker's physician of record will start submitting C9 requests for treatment. Some of those treatments, there's almost always a request for physical therapy when they try to play that game. But I've also had them request occupational therapy, follow-up visits, objective testing performed. And so there's a Supreme Court case that says once treatment has been approved that is expected to result in improvement in the person's condition, it would be inconsistent for the Industrial Commission to find a person at maximum medical improvement. So oftentimes you have to argue, you know, an MRI is not expected to cause a fundamental physiological change in a person's condition, or this physical therapy was approved, but it's only to maintain their current level of functioning. It's not expected to cause them to have an increase in their functionality. So we have those arguments at the Industrial Commission just because, once again, there's that case that says if the person has a treatment that's approved that's expected to cause improvement in their condition, then you can't get a finding of maximum medical improvement. The problem with maximum medical improvement is it has to be, you have to get your own doctor, or you have to wait for the Bureau to schedule a 90-day examination, which is an extent of disability examination. Now, they call them 90-day examinations. They're supposed to be performed after a person's been off consistently on temporary total for 90 days. And in the case of the gentleman who fell in February, his 90-day examination is scheduled for, I think it's December 21. And the Bureau actually tried to get the employer to waive the 90-day examination, which at my advice, they refused because the 90-day examination was taking place 9 months post-injury instead of 90 days post-injury. Because sometimes you do not want to wait for the Industrial Commission to schedule that exam, or they simply won't schedule that exam, you have to obtain your own independent medical examination and file your own motion. So as you can see in my example, this is a motion, and this is just a sample, where we filed a motion requesting maximum medical improvement based upon an independent medical examination performed by a doctor we chose. I'm not joking, Dr. Stephen Wonder is a real doctor that we use. He's from Cincinnati. He comes up to the Dayton area for these types of examinations. One of the issues with a maximum medical improvement examination is that you cannot terminate benefits based upon an independent medical examination until the date of hearing. So even with this motion, where the doctor's examination was performed on January 1 of 2016, if you file that on the date you receive it, you might not end up with a hearing on that issue until, right now with COVID going on, probably March, at which point the hearing officer, that would be the first time you could terminate benefits. So this is the last trick in your bag of terminating temporary total disability compensation. You'd much prefer to have them return to work on their own, have their own physician of record, release them to return to work, or find employment within their restrictions. But if none of those are a possibility, or their doctor just keeps on taking them off completely, this is your only option for getting them off of those, what can be never-ending temporary benefits. Another reason you can't receive temporary total disability compensation is incarceration. Believe it or not, there was a time in Ohio when people were incarcerated and receiving disability benefits at the same time, but that has changed. So if a person is receiving disability benefits and finds the time to commit a crime that results in them being incarcerated in either jail or prison, their benefits will be terminated. I've only seen that happen a few times in my 16 years, but it has in fact happened. Voluntary abandonment of employment. So this is a topic that I've been talking about now for, well, 16 years. If a person quits or retires and leaves employment, the case law in Ohio would say that that person has abandoned the workforce. And now if they become disabled and they are unable to work, it doesn't really matter because they weren't working to begin with. So they cannot receive temporary total or permanent total disability compensation. So I would see this in cases where, and I've seen it in both temporary total and permanent total, where the person has retired and years later they want to have surgery and they want temporary total disability compensation. Well, they can't get that temporary total disability compensation if they had voluntarily abandoned the workforce. The same is true of permanent total disability compensation. If a person says, 10 years after their retirement, they're no longer able to work in any capacity, in any job, that benefit can be denied based upon a finding that they had voluntarily left the workforce. So it has historically been defined by case law. I put the historic word in there for reasons that you will see shortly. But there are literally dozens of cases addressing this issue because there are so many factual differences between cases in determining when someone has voluntarily abandoned their position of employment. So if the person leaves work voluntarily, they can't get temporary total disability compensation. Oftentimes the argument from the other side is that it wasn't voluntary. They retired because of their injury. They quit because of their injury. They were physically unable to do their position of employment, so they were let go because of that. They left the workforce because of that. If they can show that to a hearing officer, that would be considered an involuntary release from work, involuntary separation. So they could receive in those circumstances temporary total disability compensation, despite all of this case law to the contrary. So the question is the disability causally related to the injury? If it is, and that's the reason for them leaving, no voluntary abandonment. If it's not the reason for them leaving, then you can get a voluntary abandonment. So the Klein case was a recent Supreme Court case from, I say recent, it's about 2 years old. The claimant was injured, severely injured, and was awarded temporary total disability compensation after the injury. The thing was, before the injury occurred, he had told his coworkers and other people at his job that he was planning on quitting so his injuries, I think, in the end of October. He's planning on leaving in November to go move to Florida for what he says are better opportunities and a better job, although he doesn't have anything lined up. And then after he starts receiving temporary total disability compensation, he in fact moves to Florida. The Industrial Commission terminated his temporary total disability benefits after his move to Florida based upon a finding that he had voluntarily quit the workforce. It had nothing to do with his injury because he had made that decision before the injury took place. But it was quite clear that that gentleman could not work at the time of his move to Florida. So he was disabled and moved to Florida, but could not receive benefits because he had already chosen to voluntarily abandon the workforce. The court just asked what's really causing his loss of earnings. I thought this was a very narrow, very bad set of facts because I think the answer is both. Yes, he was moving to Florida and that was going to mean that he was leaving his job and not receiving any wages or benefits, but he had planned to move to Florida so he could find a better job and presumably would have gotten a job rather quickly had it not been for this severe injury that happened to happen at work. But because of these set of facts, the Supreme Court affirmed the denial of temporary total disability compensation after the gentleman moved to Florida. The most seminal case in terms of voluntary abandonment is the Louisiana Pacific case. This is where the person was terminated for three no calls, no shows. And this is not he did not quit, he did not retire, he was actually let go, despite the fact that, whenever you're terminated, you don't consider that voluntary. The court equated that to prison. And no one's in prison voluntarily, but the actions that they undertook that resulted in them going to prison, those were all voluntary acts. The same thing is true if you're terminated under certain circumstances at which the court set forth. There has to be clearly defined prohibited conduct, and it has to be written down it can be a handbook or a policy. It has to be previously identified as a dischargeable offense. So if your handbook says, if you use offensive language, you can be disciplined up to and including suspension. You can't have your benefits terminated if you're terminated instead of suspended under the rule. And it has to have been known or should have been known by the employee. So in the cases that I've handled regarding voluntary abandonment where there was a termination, we always bring three things to the hearing. You bring the handbook that defines the clearly prohibited conduct and identifies within the policy that violation of that particular work rule result in a termination. You bring the termination letter that indicates that the termination is based upon a violation of the written work rule that said he could previously be terminated based upon a violation. And you bring an acknowledgement form showing that the person was aware of the handbook policy. They had received the policy and should, at the very least, should have known that they could have been terminated for a violation of the policy. Now, the problem with all of that case law, decades and decades of case law, which has made this easier and easier for us to argue because it is more narrowly defined how voluntary abandonment findings can be made. Our legislature stepped in to make things, I'm going to put up my air quotes, easier for us with House Bill 81, which went into effect on September 15 of 2020. This is supposed to make the issue of temporary total disability much clearer than all of these decades and decades of case law about what voluntary abandonment can be and how you can become eligible or ineligible to receive temporary total disability compensation. So this is the very clear language of the new statute, Revised Code Section 4123.56F. If an employee is unable to work or suffers a wage loss as the direct result of an impairment arising from an injury or occupational disease, the employee is entitled to receive compensation. Straightforward. If you're disabled as a result of an allowed injury, you can receive compensation. Part 2, if an employee is not working or has suffered a wage loss as a direct result of reasons unrelated to a disability arising from an injury or occupational disease, the employee is not eligible to receive compensation under this section. Once again, straightforward. If you're not working because of some reason unrelated to your injury, you can't receive temporary total disability compensation. My least favorite part of the statute is the next sentence. It is the intent of the General Assembly to supersede any previous judicial decision that applied the doctrine of voluntary abandonment to a claim brought under this section. So as I mentioned, it was previously historically defined by case law. This statute says that all of that case law is meaningless. So now when you're determining whether someone is entitled to temporary total, you just ask those two questions. Is the person disabled because of an allowed condition? If yes, they're entitled. If the person is not working because of a reason unrelated to the condition, they're not entitled. The problem is the answer can be yes to both of those questions. And I have read both claimant attorney websites and employer firm websites that have said what they believe this statute means. The employer representative firms, their websites categorically say, this statute's great. It makes it clearer for us when temporary total disability compensation can be terminated or denied because the person has voluntarily abandoned the workforce. This just statutorily makes that case law the law of the land. And then if you read the claimant websites, they say, this is great. Voluntary abandonment no longer exists. If you had your benefits denied because of a finding of voluntary abandonment, please call us because we believe we can get your benefits reinstated because there's no such thing as voluntary abandonment anymore. So at present time, I think we don't really know what the courts are going to do in terms of defining when a person can and cannot receive temporary total disability compensation under the statute. They can no longer, when this matters end up in court, attorneys will no longer be able to point to the decades and decades of case law defining when a voluntary abandonment occurred or when did not occur. And once again, attorneys that are workers' compensation specialists disagree as to what the meaning of this statute will be. And so in workers' compensation, there are two appeal paths for a matter that's finally decided by the Industrial Commission. If it's an issue of allowance, you appeal it to the Common Pleas Court and you end up in trial. If it's an issue of disability benefits, that is appealable to the 10th Appellate District Court of Appeals, where it will go directly to a magistrate who will make a decision, who will then have that objections to the magistrate either affirmed or not by a panel of judges at the 10th District Court of Appeals. So that can take, that process can take more than a year for a decision to be made. So right now we have probably some cases just initially in the Industrial Commission right now being heard over what this statute means. I expect that we'll see some cases filed into the 10th Appellate District sometime in 2021 and may see our first decision on what this statute means probably not until 2022. So I just wanted to go over those same cases. I'm repeating the slides, and Carl, our IT person here, reminded me, he thought that I had repeated these on accident. I did not. I put them there on purpose. Once again, Mr. Klein was injured and he received temporary total disability benefits following his injury. So is his disability and inability to work related to his injury at work? Yes. And he moved to Florida and had intended to move to Florida before the injury occurred. So is his inability to receive compensation, or is his inability to work right now, or his failure to be working right now unrelated to his injury? Yes. So both of those things are true. The injured employee, under the statute, the answer is yes. So what's the result? Should he receive temporary total disability compensation? What is causing his loss of earnings? Is it his move to Florida or is it his injury? What's the answer when the answer to both those questions is both? I mean, it's yes. Louisiana Pacific, once again, the person was was terminated, but then became physically unable to return to their former position of employment. So they'd been terminated. They weren't working because they had violated a written work rule, and they knew that could result in their termination. So they're not working because of that. So the second part of the statute, the reason that they're not receiving compensation is unrelated to their claim entirely. And their allowed conditions have now made them physically unable to work. So the answer to both questions is yes. So what does the Industrial Commission do when the answer to both of those questions under the statute is yes? Unfortunately, I don't think we're going to know that answer for quite some time. I know that claimants are going to argue what those claimant websites said, and I know that I and all other employers' counsel are going to argue that this just statutorily defines what was previously put into the case law, that if a person has voluntarily abandoned their employment, they're not entitled to temporary total disability compensation. Until the courts speak, I think we're going to have disparate decisions between different hearing officers, depending on whether you're in Dayton or Columbus or wherever in the state. There may be differences in the way the hearing officers rule on this particular issue. So, workers' compensation claims are very complicated. And when someone is off work, as I mentioned, you have a lot of options on what to do. So my advice to everyone is, call your attorney, call whoever your attorney is, your counsel, to talk over these issues before you start paying salary continuation, definitely before you make a light duty job offer. And then after someone's been off for some period of time, it's important to consult with your counsel on whether you can get the Bureau to move on a 90-day examination or to schedule your own independent medical examination, because there are a lot of factors that you take into consideration before you take on the expense of getting one of those examinations performed. So hopefully this has been helpful, although my statutory answer of I don't know what the statute means probably is going to make you have more questions than it will answers. Hopefully this has been helpful for you. And I just wonder, that's the end of my presentation, if anyone has any questions for me.
Well, Josh, thank you very much. We greatly appreciate you taking the time to give this presentation today. Josh is one of my partners at Coolidge Wall, and it has absolutely been a pleasure working with him for this period of time. So we do appreciate him speaking on this topic. I would like to remind everyone that the presentation will be emailed to you, so you will have that information. I also wanted to pass along that Julia and Deanna wanted to send their holiday cheer and well wishes to everyone, as do I. It certainly has been a very challenging 2020, but I hope everyone stays healthy and can enjoy the holiday season. So enjoy your day, everybody. Thanks so much.